Showing on Law Weekly today, an assessment of how well the judiciary fared in year 2019. We have the views of a senior advocate of Nigeria, Professor Koinsola Ajayi. We also have the views of some other lawyers on what the judiciary can improve on in year 2020. Plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shuyeli. The end of the year is usually a good opportunity to look back and reflect on what transpired during the year and what could be done better in the new year. On today's edition of Law Weekly, we do just that with a professor of law and a senior advocate of Nigeria, Professor Koinsola Ajayi. I began by asking first his assessment of the judiciary in the year 2019.
Given the interesting times we live in, which is that there's abysmal failure everywhere, judiciary has tried. But on the other hand, judiciary being what it is, with the enormous powers given to it by the Constitution, with the confidence reposed in us, the public, in them, they just haven't done well enough. They haven't done well enough to ensure that the true purpose of the Constitution is met, which is that the nation is formed for the peace, order, and good government of the people. And that's not happening. We're not seeing that coming through the cases. Cases are still delayed. The judgments we get are still very disappointing. And there's still a lot of resort to self-help by a lot of people. And that simply is because they didn't have confidence in the judiciary. So, on the basis of what is expected of them, it's rather unfortunate that I would give them a pass mark.
How much of this underperformance on a real scale would you attribute to leadership, the leadership of the bench?
But this is the irony. Every judge is, if you like, a god. So he has no boss. And so, for instance, I've criticized the attitude of our appeal courts that derogates and denigrates trial courts or lower courts that distinguish their cases or find better wisdom in the law and therefore depart from earlier decisions. And they call it rascality. And I don't think that cannot be right. A judge is a judge, and it just so happens that they sit at different levels. And from the places that we see good laws written by the courts, and especially England, from where we borrow most of our common law, most of those judgments are from the High Court. But coming back to question of leadership, so my first point is that, all judges are equal as far as I'm concerned, and they all should do what they should need to do. Every judge is supposed to be independent. But then we fashion this system which unfortunately sort of has created a leadership in the bar. You find even amongst judges, not even the formal structures, the way judges genuflect to the head judge is at times sickening. And you find some head judges behaving as if they were sovereigns. You have head judges behaving as if they were governors. But that's not what that's not what we learned. That's not what we know. So I think that's unfortunate. The fact that there are some judges that begin to subject themselves to judges that are senior to them, behaving as if they were servants when indeed they are equals. And then in the formal system, is the fact that we now have a structure where the means and the way by which we appoint judges makes some of us rather worried. So I'm very worried, as indeed many lawyers, and I'm sure some judges, that the Chief Justice of the Federation has said that there will be no appointment to the Supreme Court from the bar. Now the first point is this: really doesn't lie in the mouth of the Chief Justice of Nigeria, because he is not the person that appoints judges to the Supreme Court. The Constitution vests that power in somebody else. He is a member of the committee. He is the chairman of NJC and NGI and all those bodies. But then he has just one vote, or a casting vote at best. But so it's sad. It's a sad commentary that because we thought we had gone far. Justice Onage started the process, was truncated, and we mustn't forget that some of the best judges in Nigeria have come directly from the bar. Justice Elias, from Attorney General to Chief Justice of the Federation, from there to the World Court. Justice Nnamani, one of the best judges we've had, from Attorney General to the Supreme Court. So, and in England, lately, they've appointed people from the bar straight to the Supreme Court. In America, people have gone from the bar or from academia straight to the Supreme Court. I don't see any reason why we should be different from what is progressive.
There appears to be a consensus among lawyers that the federal government has not done too well in its relationship with the judiciary, and most people point to disobedience of court orders. But can the bench just fold its arms and allow things to go on? Is there anything that the judiciary can do to ensure that its orders are obeyed?
Judges have no guns, judges have no, the courts don't have an enforcement arm. The Supreme Court indeed has no bailiff section, sheriff section as such. They have bailiffs that just have papers. Supreme Court doesn't enforce judgments. Only the high courts can enforce judgments. But then they're just bailiffs, and when they go out to enforce judgments, they need the cooperation of law enforcement agents. Law enforcement agents are under the control of the Commander-in-Chief of the Armed Forces. So, truth of the matter is that by Mosaic law, there's nothing the courts can do. Tooth for tooth, eye for eye, there's nothing they can do. But by the new covenant, which relies more on wisdom and knowledge rather than raw power, there's a lot that the Supreme Court can do. So the Supreme Court, for instance, needs to know, because I don't think it is assuming that role, that it's a policy court and should be providing guidance to society by, shaping the philosophy of the nation as a whole. And that drives into the conscience of the people. So the better the justice we get from them, the more meaningful their cases are to our lives, the greater they shape the narrative of the nation, the greater the power they would have. And then it would be the people that would enforce their judgments, because the power of the judge is in the confidence of the people, and the power of enforcement therefore lies in the people. I hope our government will not allow us to resort to self-help in enforcing judgments of the court. But then it's clear, though, that what some courts have done is to refuse to listen to government where it disobeys it. Interesting thing is that this government says it's a government of the rule of law, and they do everything by the rule of law. And they indeed rely on the courts to do a number of things. After all, they supposedly removed Onoge in accordance with a court order and with the orders of some tribunal. Whether or not the order that was laid upon is a kangaroo order is a different matter, subject of another day. But the point is, they lay claim to this, they use it as a badge of honor, and so the court should be more insistent that if you don't obey the order of Justice Shola in Kutuwenji, then Justice Jack would not entertain any case involving government anywhere. So whether that is prosecution or a civil case, they just refuse to entertain government. And then maybe that would begin to force government itself to do things right.
So are you saying that individual judges should take judicial notice of court cases that involves government before other judges and then act on same?
Yeah, because you see, the judges are not trade unionists. I'm not expecting them to sit down as a trade union to do anything. But the fact is that I, Judge X, can refuse to take a case. And it's when I refuse, and Justice Shola refuses, and Justice Channel refuses, and Justice Momo refuses, and Justice TV refuses, and then the government sees that, oh, well, I'm not going to get anything done again. It begins to do something. And I think the other point is that the other arms of government, in this case the legislature, must rise to the occasion and hold government to account. Governments depend, the arms of government depend on each other in order to function. And so we can't afford to leave the judiciary at the mercy of the executive, which is what is happening. So the other arms of government need to. And I think part of the things that we need to do as a nation is just have strong institutions. So if you have a very strong institution, just say, well, sorry, Mr. Minister, this is what the court says. I'm sorry, I'm not going to do that. I think until we get to that stage, we'll probably continue to have the Malami Buhari problem we have today.
In 2020, though, what needs to change, especially with access to justice and the speed of justice, so that it can be better?
Well, access to justice is fantastic in Nigeria. It's very easy to get into courts. The only place where it's slightly difficult to get into court now is Lagos State, where the filing fees are high. I'm one of the proponents in support of that level of fees, because it means that it drives out unserious litigants. The only thing is that you cannot now have high filing fees and not have costs that are high. Because if I've spent 5 million naira on filing fees and I win the case, and you then give me 100,000 naira cost, then it's a nonsense. So, it just, what filing fees helps us to do is to, make us think twice about, prosecuting these cases. The challenge with the fact that we have open access to justice is that the courts are flooded with just too many useless cases, just too many. And the judges then go through the motions of hearing all these cases. And what do you have? These judges are human. So they have 10 cases on the docket, 8 are useless, but he's still going to go through the motions. So he spends whatever percent of his time on dealing with these useless cases. So he has only so little time to deal with the huge cases. So even a very, very good diligent judge will be under pressure to write very good judgment. So I think we need to begin to look at the, effect of this open access on the quality of justice and the speed. Because then also is the fact that because I have 8 useless cases, I just have to wait. So instead of my case being dealt with on day 1 or day 2, I have to wait till day 9 because this judge still has to deal with all these useless cases. Second point is that judges need to be more courageous, especially at the trials courts. They need to be more courageous in dealing with lawyers that are bullies. So you have lawyers that are bullies, bully judges. So the judge is a master of his court and controls his court and should be able to be firm and throw out cases without permitting any form of dilatory tactics, which a number of us engage in. Second point of courage, I think, that is needed by the trial court judges is that they must be free to decide cases in the manner in which they believe are just and are in keeping with judicial precedent. The third thing I think that we need to do is that the Bar Association needs to get a lot more serious with discipline of its members. And, in discipline is not only sort of engaging in, diversion of clients' monies and things like that, which is the reason why you find a lot of lawyers being disciplined. But lawyers that actually engage in serious abuse of process need to be disciplined. A lawyer that sits down with his clients to assist the client to depose to complete lies that the lawyer himself knows to be untrue should be disciplined, because the lawyer is an officer of the court. And therefore, if the client comes to you and says, well, look, I owe money, but it's okay, no, just lie that you don't owe the money. The lawyer should be disciplined. Now, it's different from if you come to me, you say you owe money. I say, is it true? I look at your documents that appear that you don't owe money, and I assist you to prepare your documents. That's fine. But where I know that it's a lie, it's actually irresponsible and unprofessional